we're going to move right into our program here. I hope that you've enjoyed the presentations as much as I have. And as some of you heard me say first thing this morning, I could not be more excited if I were speaking. And Marla laughed at that. She knows what I'm talking about. Events like this do not happen by accident, successful events. And so there's many, many people who have contributed. You've seen the effort that our faculty, our world-class faculty, have made in attracting speakers and in participating themselves and attending the audience, attending in the audience and contributing. Our staff puts on, in fact, we're right now doing, literally, we counted this up, 5 times as many events as we did 4 years ago. And the event staff is amazing. Linda Feldman, Linda Harvey, Liz Alper, Chris Gibbons, Clorinda Valenti. Clorinda, where are you? You're a relatively new member of our team. There she is in the back. She's extraordinary, and so many others. And our servers, we're very appreciative of you coming on here. Today especially has been a challenge, and our IT crew, who's been in the midst of major overhauls and upgrades, deserve a shout out. Lloyd Carew Reed, Alan Volney, Kirk Banton, Juan Pastor Jr. Where's Juan? Well, tell him we gave him a shout out. He's now on the lam. And Anthony Burrows. We're really, really appreciative. I think last week was a world's record. In the 3 years I've been here, three years and a quarter that I've been here, it was the first week where I didn't have one complaint about IT. And it's not like we're a low-maintenance group here, right? So that's really special. We have a wonderful program that's beginning at 1:30 sharp downstairs with my artist friend and a person who I deeply admire for his work, Hugh Locke. So we're going to want to conclude. So we're going to jump in while you still are eating and start the next session, which is going to be fascinating. We have no choice. We have 3 participants and one gentleman who's come a long way to be here with us today, and we're very, very grateful for that. So Joel, I'll ask you to do the honors. Professor Joel Gore.
Thank you, Dean Allard. I'm a professor here at the law school. I teach constitutional law, and for that reason, it is a particular honor to be part of this glorious day where we celebrate perhaps the 2 greatest documents of democracy, the Magna Carta and the Constitution. But before we do that and hear from our distinguished keynote speaker, I want to take a moment to thank Dean Nick Allard, the quarterback of the great team of administrators and faculty members and others who put together this great day. I've been part of many Constitution Day programs, but today's full court press is in a league of its own. And so much of that has to do with the energy and the enthusiasm and the vision of Dean Allard. He's so great at giving credit to others, I think it's appropriate to give credit to him. So Dean Allard. The Magna Carta is 800 years old this year, and the Constitution is 220 years old today. And the link between the two over the centuries of time is enduring. The Magna Carta has been described as the owner's manual to the greatest form of government the world has ever known. It contained the seeds of so much of what today we take for granted. As the American Bar Association put it, the Magna Carta is widely recognized to be a pillar of liberty, major source of the modern concept of executive accountability, and foundation of the rule of law in the United States, the United Kingdom, and the Commonwealth countries. Despite its blemishes and warts, it was, after all, a product of the Middle Ages. The Magna Carta codified the notions of legal restraints on arbitrary and capricious government and helped pave the way for the Constitution adopted 5 centuries later. When the framers met that September day in Philadelphia in 1787, to sign the document and hit the 18th century version of the send button, they launched a legal regime that would embody the concepts of limited government, separation of powers, individual rights, due process of law, so many of which ultimately traced back to Magna Carta. The Supreme Court's clarion call in the famous case of Marbury versus Madison, that the government of the United States has emphatically been termed a government of laws and not of men, and that the Constitution is our highest law, likewise has its origin in Magna Carta. My own experiences confirm the powerful interrelationship between the two landmark documents. As a young ACLU lawyer, I was asked to write a book about due process of law as part of a Know Your Rights series of books. It was a great honor to work on the book, and the very first passage I cited in the book was from the Magna Carta, and it read as follows: "No free man shall be captured or imprisoned or deceased or outlawed or exiled or in any way destroyed, nor will we go against him or send against him except by the lawful judgment of his peers and by the law of the land." Pretty good for 1215. I then observed from the Magna Carta's by the law of the land to the Constitution's due process of law, the concepts that this book will explore have been the indispensable preconditions of the liberties that we have come to cherish. So, because of the Magna Carta and the Constitution, we are all dedicated to the rule of law. But as our speaker will note, that touchstone may often raise as many questions as it resolves. Because the concepts of the rule of law, the concept requires us to determine not only what the rule is or what the rule should be, but who ought to decide that question. And we could not ask for a better speaker to address those timeless questions than Dr. Michael Pinto Dushinsky. His career as a political scientist, scholar, advocate, consultant to governments, leader of numerous global professional organizations, has been dedicated to studying and advancing the rule of law, but with the full knowledge of the complexity and uncertainty that such an enterprise entails. Educated at Oxford University, from which he received with honors a BA, an MA, and a PhD, and at which he served as a scholar for a quarter of a century, his life and work have epitomized the concept of a public intellectual. As a Holocaust survivor, he is particularly aware of the vital role played by the rule of law, and he has worked with various government and international agencies on issues of slave labor. He has also served as a global expert on issues pertaining to, promoting democracy and constitutional reform and advising international organizations, governments, and public bodies in over 25 countries. His work on issues of political funding, what we call campaign financing, has left someone like me, who knows a little bit about those issues, in awe of the prolific outpouring of scholarship and advocacy he has produced just in that particular vineyard. In fact, he sat in on my campaign finance law seminar this morning, and it was a wonderful experience for me and for my students. Most recently, Dr. Pinto Dushinsky was appointed by the British Prime Minister in 2011 as the only non-lawyer on the United Kingdom's 8-person commission on a Bill of Rights. When he finishes his remarks, we will have commentary from distinguished visiting professor Judge Andrew Napolitano, whom I'll introduce at that time. After that, we'll open the floor for questions from the audience. And let me introduce Dr. Michael Pinto Dushinsky.
It is a privilege to be invited to participate in this very special occasion of the 800th anniversary of Magna Carta and of the anniversary of the US Constitution. The Dean and the whole events team have invested a great deal of time, care, and hospitality, and thank you very much to all of you. I must admit that part of the attraction in coming was the chance to share the day with Dick Howard, one of the greatest US constitutionalists, and the prospect of meeting the BLS alumnus Judge Corman and BLS Professor Joel Gora. Professor Gora and I share a long-standing involvement in policy issues related to campaign finance. But it's a special but daunting bonus to have Judge Andrew Napolitano as commentator although he did start by giving me a lovely Italian hug, and so I hope that nothing that he says is too critical afterwards. There are questions about rights, liberties, and the rule of law are not at all simple. Many of them remain unresolved and are greatly perplexing today. I aim to speak for 30 minutes, and this is timed out. I'm reading this out, and I'm told that 130 minutes, 130 words a minute does it, and then I get 26 minutes. So we'll see how fast I go. The problems include what may be called everyday justice, as well as some of the fundamental matters facing the recent UK Commission on a Bill of Rights. I will also add a few words about a matter close to my heart and my background as a child survivor of the Holocaust in Hungary, namely justice, law, and the Nazis. My remarks will have three parts. First, I feel obliged to start with everyday justice. High principles are of little value if they're ignored in lower courts or if there are severe financial or practical impediments to their implementation. Unfortunately, the practice of law in the United States, as well as the UK, falls well short of the ideals which have emerged from Magna Carta and which are expressed in the US Bill of Rights. Second, we need to ask whether the rule of law, obedience to established legal procedure, is in all circumstances conducive to justice. Most people do not realize that the German Federal Republic maintains that, as one of its ambassadors in London told me, strictly speaking, those were his very words, there was nothing illegal in slave labor in the Buna-Monowitz camp at Auschwitz. Around 1996, my friend, the late Rudy Kennedy, gave an account of his shocking experiences there to the ambassador, and it was then that the ambassador turned to me to say that, strictly speaking, Rudy's treatment had involved nothing illegal. Moreover, German officialdom has determined that slave labor is an incorrect term anyway, and that the euphemistic forced labor is to be preferred. They had a 50-person conference at the former concentration camp of Buchenwald, and that was so determined. If slave labor at Auschwitz really was legal, does that not make a mockery of the language of rights and liberties? Third, and this will be my main topic, with the advent of democracy, there are disagreements about the implications of rights for the boundaries between the power of the judiciary and other branches of government. Discussion about this is only now emerging as a prominent dilemma in Britain. There is an added dimension of the debate in Britain. Apart from the question of the desirable separation of power between the UK Supreme Court and Parliament in London, there's a harder question about the desirable separation of power between the British legislature and two powerful international courts whose jurisdiction Britain has also accepted, and these are the courts of the Council of Europe and of the European Union. And so that, in brief, is what I'll be going through. First, everyday injustice. Given huge financial inequality and the extremely high costs of litigation, is the principle of equality before the law a mere pipe dream? And what of the racial dimension of present-day law? What about the huge growth in the past 40 years in the number of incarcerated persons? I'm thinking especially, but not only, about the United States. In the USA, the proportion of the population in jail is exceptionally high in comparison with other countries, higher even than in Russia and China. And since the early 1970s, there's been a huge increase both in the absolute number of people jailed and in the proportion of the population imprisoned. The steep upward trend is the same in the UK. In the 40 years from 1972, the rate of violent crime in the US remained constant and homicide halved, yet the imprisonment rate quadrupled. Clearly something has gone badly wrong. Since the 1960s, the civil rights of black Americans have greatly advanced. When I first journeyed across the USA by Greyhound bus as a student, I first encountered signs on toilets in southern states marked whites only. That, thankfully, is no more. Paradoxically, blacks are now far more likely to be jailed than in the days of legalized segregation. Moreover, the USA and the UK share a shameful statistic. Blacks are 7 times more likely to be in prison than whites. I felt obliged to start, albeit far too briefly, with these routine but vital problems before proceeding to my second topic, the legal status of the Holocaust. In early July 1944, thousands of Jews were locked for nearly a week in an improvised concentration camp north of Budapest at Budakalas. Once they were exhausted, famished, and pillaged, they were put into trains bound for Auschwitz. That is all except some 18 families who were ransomed in a controversial deal. I was one of the few lucky ones there. It was one of 4 ghettos and camps in which I was immured during the first 19 months of my life. Forward to the 1990s and the futile quest for a measure of justice for the surviving victims of Auschwitz. Having played an active part in this campaign, its failure is a source of sadness and outrage to me. On the steps of the Council of Europe, the parent body of the European Court of Human Rights, a large inscribed stone commemorates the victims of Auschwitz. Yet, this monument expresses crocodile tears. For not only did most of the perpetrators go scot-free, not only did negotiations for slave labor compensation, led on the US side by Stu Eisenstadt, result in insulting pittances for former slave laborers and the abandonment of cases before US courts by class action lawyers acting in at least some cases without the approval of the survivors they represented. Not only did Eisenstadt, in my opinion unreasonably, claim that his efforts brought at least imperfect justice, whereas in reality there had been a huge symbolic and practical failure. Not only did some of the class action lawyers who had led survivors to believe they were acting pro bono receive fees amounting to several $1 million each. Not only were survivors required to sign away all legal rights if they wished to receive the derisory $7,000 on offer from German corporations which had used their labor for years. And not only did the German government suggest in evidence to the US courts that surviving Holocaust victims should be grateful that they'd been slave laborers, forced laborers, because they thereby avoided the gas chambers. They seriously put that argument through to courts in this region of the US. But also, the crucial point for any consideration of rights in the modern world, Germany refuses to accept that victims are legally entitled to sue for compensation. any small compensation they receive must be regarded as a goodwill gesture and not as a legal admission of wrongdoing. Indeed, Germany may be correct in this stance, for the corporations in Nazi Germany were acting under Nazi laws. To make them liable would require retrospective legislation, something against accepted notions of the rule of law. This dreadful example raises a deep question for jurisprudence. How do we assure liability for gross abuses of human rights under regimes which do not incorporate rights in their legal system and practice? At dinner tonight, there will be an address by the investigative journalist Dina Gold about the success of her family in obtaining multi-million-dollar compensation for a major family property in Berlin stolen by the Nazis. But make no mistake, the success she will describe must not avert attention from the core scandal I've mentioned. Certainly, I regard it as a major item on my personal bucket list to campaign to achieve recognition of the German government that slave labor in the concentration camps must be recognized as illegal. Without such recognition, the future welfare of the European continent must be subject to severe doubt. I will now go to my third topic, the tension between democracy and constitutional rights in Western democracies, and especially in Britain and the United States. In the time of King John, the sovereign ruler was the king. In Britain and most of its former colonies, in what used to be called the British Commonwealth and is now the Commonwealth, the hereditary monarch is still sovereign, but in a very different way, normally called the Queen in Parliament. Namely, the Queen merely rubber stamps laws enacted in Britain, Canada, Australia, New Zealand, and elsewhere by their legislatures. The basic constitutional separation of powers, therefore, is no longer between the king and the barons, but between the legislature and the judiciary. And it's this key relationship on which I will focus. From the time of Magna Carta, rights and liberties in the United Kingdom have been embodied in various laws over the centuries, as well as in rights developed by judges in what is called common law, that is, legal precedent. But unlike the USA, Britain, of course, has no single constitutional document. In theory, no law has an entrenched status. When a new House of Commons is elected, it may, with limited input from the unelected House of Lords, repeal any existing law by a simple majority. The ability to do this is known as the doctrine of parliamentary sovereignty. Certainly, it's for judges to rule on the meaning of existing laws and to reach verdicts on specific cases without political interference. But if the House of Commons, led by the Prime Minister, who normally enjoys a majority, does not approve of the way in which the judges have interpreted the law, they're able to change it. At least that was the traditional British constitutional position until recently. But there have been profound changes in recent years. They did not arise from the recommendation of a constitutional convention. Indeed, the changes have crept in almost unnoticed. Only in 2010 did they lead to what has the makings of a constitutional crisis that has implications not only for the UK, but for other countries, including the USA. It's convenient to summarize by mentioning three developments. First, since the late 1940s, the UK has been a signatory of a series of international conventions which UK judges and UK governments have treated as legal commitments. For example, the UN Convention on the Rights of the Child, Convention Against Torture, and so forth. Second, the UK acceded in 1972 to what was then the European Economic Community and then became the European Union. In a famous set of cases, British judges ruled that for as long as the UK remains a member of the European Union, EU law trumps British law. EU law is subject to the Court of Justice of the European Union in Strasbourg. So far, EU law has mainly concerned important economic and regulatory matters, but as we'll see in a moment, this is changing. Third, Britain was instrumental in the creation of a body called the Council of Europe, and this has a wider membership than the European Union. For example, Russia and Turkey are members. In 1950, members of the Council of Europe drew up a European Convention on Human Rights, a document very similar to the Bill of Rights incorporated in the US Constitution. The Council of Europe also set up a court in Strasbourg. Without fanfare, without commitment to follow its rulings, and initially as a temporary move, the British government in 1966 permitted persons in the UK to bring cases before the Strasbourg court if they were dissatisfied with the rulings of the UK courts. In 1994, the Conservative government agreed, without any debate in the House of Commons, to accept the permanent jurisdiction of the Strasbourg court in cases involving the European Convention on Human Rights. Moreover, in 1998, the Labour government enacted a Human Rights Act which incorporated the wording of much of the European Convention on Human Rights into UK law. So effectively, the UK has three Supreme Courts in London, Strasbourg, and Luxembourg. I have no time to explore the complexities this creates, if I understand them. Rather, I'll understand what should happen if the House of Commons disagrees with the judges in Strasbourg. Such a case did, in fact, arise under the Labour government of 1997 to 2010 and is still unresolved. As often happens, a small issue may raise fundamental questions about who has the final say. You'll be relieved at this point that I intend to simplify drastically in order, well, let's see. I'm sorry, I'm reading. I don't usually read, but since we're being filmed, I feel I must safeguard myself from saying anything more stupid than normal. And indeed, what happened was that the pages I have been given this is completely your fault, Joel.
I just printed it out.
Yeah, but we're one page missing.
Oh, my goodness.
That's why I thought.
I apologize.
Well, so you'll be relieved that this will be shorter. But it will lose a certain coherence, as it had actually been fairly carefully prepared, much more than I usually do. But I felt this is a very important occasion, and I wanted to make a prepared statement. The page has been found. So this will be a minute more, sorry. Such a case did, apologies, Joe. Such a case did in fact arise under the Labour government of 1997 to 2010 and is still unresolved. This case is not a conflict between the domestic legislature and the domestic judiciary, as has been the frequent experience in the USA. The conflict has pitted the UK House of Commons against an international judiciary, the court in Strasbourg, consisting of one judge from each of the 47 member states of the Council of Europe. And so this court, which has challenged the sovereignty of the British Parliament, has a judge from Turkey and from Russia, from Albania, from Liechtenstein, Monaco, San Marino, and Andorra, among others. Not that I'm mocking it. That's what happens when you go off text. I'm sorry. Nothing libelous, anyway. The issue in question concerns the voting rights of prisoners. According to the UK law, those serving prison sentences are not permitted to vote. Following a case brought by an axe murderer, the Strasbourg judges ruled that a blanket ban on prisoner voting contravenes the European Convention on Human Rights. Nevertheless, the House of Commons has voted by a 10-to-1 margin to maintain the existing law. The standoff between the House of Commons and the judges in Strasbourg is still to be resolved. I have a certain relationship with this gentleman, the axe murderer, because after being for a year and a bit on the UK Commission on a Bill of Rights, which wasn't looking at the question of the rights of Parliament as against the Strasbourg court, which I wanted to look at, I resigned. And he then blogged that he had been responsible for my resignation. And, so to speak, he had claimed my scalp. I thought that I can't let my daughter see this because, as an axe murderer, this came rather too close to home. The current Conservative government is committed to a change in the country's relationship with the European Court in Strasbourg, so that the court's decision should no longer be binding, but should have advisory status alone. Critics claim that such a measure would be unacceptable to the Strasbourg court and to the Council of Europe, and would force the UK to leave the Council of Europe and even to leave the European Union. Matters are to become even more intricate because a recent European Union treaty, the Lisbon Treaty, has incorporated a wide-ranging European Charter of Fundamental Rights. And the Court of Justice of the European Union in Luxembourg has responsibility for adjudication. The UK negotiated a protocol opting out of the legal as distinct from the moral obligations of this document, but constitutional lawyers are confused and dubious about whether this opt-out provides the legal protection promised by the Labour government which negotiated the treaty. So Britain now has 3 separate bills of rights as well as 3 Supreme Courts. And these are the Human Rights Act, which the current Conservative government is committed to replace with a nearly identical British Bill of Rights, the European Convention on Human Rights, and the 47-nation Council of Europe. That is the 47-nation Council of Europe, and the Charter of Fundamental Rights of the 28-nation European Union. Further commitments are included in the so-called Good Friday Agreements to end terrorism in Northern Ireland and in legislation concerning devolution in Scotland. You'll be relieved to know at this point, and this is where I come back to my page 8, which is nearly the end, I intend to simplify drastically in order to consider the core problem with which you will all be thoroughly versed. When procedural rights, such as habeas corpus, and substantive rights, such as freedom of expression, or a ban on torture are set out in a legal document, responsibility for deciding cases rests with judges. When judges hear a case, they not only reach a verdict based on the facts brought before them, in addition, they may need to interpret the meaning of the rights in question. Moreover, and this is something almost insultingly obvious, but nonetheless crucial, the wording of legal documents setting out fundamental rights may be so broad that the scope for judicial interpretation may be very wide. Furthermore, different rights may be inconsistent with each other, and it will then be for judges to determine which has priority. In short, a system of rights inevitably allows judges to go beyond the task of deciding particular cases so that they become backdoor legislators. Many have and will argue that this is a desirable state of affairs. Members of the legislature tend to be too easily swayed by popular passions of the moment. They have a strong incentive in a majoritarian democracy to appeal to the masses and to ignore the interests of members of unpopular minorities or the interests of non-citizens. Senior judges, according to this view, it is indeed the predominant view in legal circles and among the elite opinion in Britain and in much of Europe, are better positioned than legislators to determine the meaning and application of fundamental rights. We find similar admiration for judges and a concomitant cynicism about majoritarian democracy in the works of the late Professor Ronald Dworkin. Before exploring further, I want to make two statements, of which the former is almost banal, but which has not yet been fully debated in Britain. In a democracy, bills of rights lead sooner or later to clashes between judges and elected legislators. The question is how best to deal with such clashes, or, putting it in different words, what are the most appropriate checks and balances between the different branches of a democratic government? My other statement is that it's far harder to create a workable set of checks and balances when the national legislature clashes with an international court, which is the situation in Britain and will be increasingly the situation throughout Europe. We are suffering from the fact that wholly insufficient thought has been given to the constitutional implications of the international courts which have come into being since the Second World War. This applies in particular to the two courts about which I've spoken, but there are others as well, including the International Criminal Court in The Hague, the Inter-American Court of Human Rights in San Jose, Costa Rica, and others. Though established in 1959, it's only since 1998 that the European Court of Human Rights has operated on a full-time basis. Its power derives from the entitlement of individuals in the member states of the Council of Europe to take cases directly to the court, and from the wide remit which results from the broad wording of the rights embodied in the European Convention on Human Rights. The unanticipated constitutional problem is that the court, being an international court, is virtually unaccountable. The system of checks and balances which exists within the US between judiciary and the two other branches of government may work imperfectly, but there is no similar structure when it comes to national governments and the European Court of Human Rights. The constitutional challenge now for my country is to devise a means whereby national legislatures have an ability in the most exceptional circumstances to override judicial review of their laws by Strasbourg, while at the same time ensuring that decisions of the court may not be casually and repeatedly ignored. This is an intellectual as well as an urgent practical task for the recently elected British government. I will not offer a precise solution in this address because of lack of time, but will be prepared to try and do so in the discussion period if you wish. What I will say is that we need greater caution about international courts in general. I recommend that whenever it's proposed to establish or to extend the powers of an international court, it's vital to consider how it can be both independent but also politically accountable. This is dreadful. If I don't...
Michael, that's kind of a good place to break.
Well, that's what I thought. It is actually...
You'll get Reverend Napolitano to comment and then have some Q&A that'll bring out the rest.
It was very nearly the end, and clearly that was a natural break. Thank you, Mr. Dean.
The commentator needs no introduction to many of you. Judge Andrew Napolitano is a distinguished visiting professor at the law school, had a highly successful career in private practice, was one of the most well-regarded and youngest judges in New Jersey, and for the last 16 years has been the senior legal analyst for Fox News, and he's on every day commenting on the most important issues and doing so in the most incredibly insightful way. And he's also a good friend. Judge Andrew Napolitano.
Thank you. Thank you, Professor Gora. Dr. Pinto-Dushinsky, I'm sorry to tell you that the version of your remarks that Professor Gora gave me last week was complete and the pages were numbered, so I don't know how this happened to you. When one is, just a word of advice to everybody in this room, when one is asked to comment on the talk of someone whom one hasn't met, don't sit next to them at lunch because it will end up tempering what your criticism was going to be. You have heard the words of a remarkable campaigner for human liberty in our era, and it is indeed an honor and a pleasure to sit with him, to have lunch with him, and to attempt to comment on some of his work. I did get a chance to read your words completely and in order, and they are brilliant and challenging and open up a lot of areas for discussion. So I will confine mine briefly because I know a lot of you want to engage Dr. Pinto-Dushinsky in some Q&A. I will confine my comments just to the reason for which we are here today. In every law school in the United States of America, the Constitution of the United States is being celebrated today, except here, where we are going back 600 years earlier, thanks to our Anglophilic and wonderful dean, to celebrate the Magna Carta, which in large measure has been referred to as one of the sheet anchors of our own liberties. And we all know the basics about the Magna Carta. It was never voted on, it was never approved. The Pope rescinded it, eventually came back into play. But its play in English history has a couple of very interesting events. One is the significance of Magna Carta as a sheet anchor of British liberty is not so much in what it said or in how it came about, but rather is in what people thought it said and how they thought it came about, and how all sides resorted to it for support for their arguments. Case in point, in 1628, the king was Charles I, the only king to be executed while in office, and Parliament engaged in a 3-day debate. And the debate was the following: is the king above the rule of law, or is the rule of law above the king? Now, I could ask you here to tell me how you think the vote turned out. Well, here's how it turned out. First, during the debate, both sides appealed to Magna Carta. The monarchists in the House of Commons argued that the king was a more reliable preserver of human liberty than a rabble-rousing majority in the Commons. And the Commons argued that the king was a madman and couldn't be trusted to preserve liberty, and they both made arguments about phrases in Magna Carta which didn't exist. But they resorted to Magna Carta because of the aura around it and because of the mythological concept that it is the creator and preserver of rights in England. They took a vote, and the rule of law won by 12 votes of about 300 cast. Fast forward 15 years, Charles I is executed. Somebody opened up the ballots and recounted them. Turned out the king won by about 12 votes. Of course, by then he was dead. He had been executed, and his successor was on the throne, and things were a lot more copacetic. Magna Carta, of course, did not stop Henry VIII from slaughtering his wives. It didn't stop George III from enslaving the colonists any more than the Constitution of the United States initially stopped slavery here. However, in this country, we do have, for the most part, because it's not the same in every state, I came from a state system which enjoyed lifetime tenure, unelected, life-tenured judges. Unelected, life-tenured equals total judicial independence. So my argument to the good Professor Pinto-Dushinsky is this: it is nearly impossible to preserve human liberty without an independent judiciary, because if the majority feels threatened, it will simply vote its own interests, whether the majority is parliamentary sovereignty, parliamentary supremacy, or a congressional majority. And many of the growing pains through which the British government is going, so beautifully described by Dr. Pinto-Dushinsky, the American government went through 200 years ago, with Barron against Baltimore and Calder against Bull and McCulloch against Maryland, and cases with which we're all familiar from the earliest days of our studying the Constitution and the relationship of the Supreme Court of the United States to individual states and state courts.
What about Dred Scott versus Stanford?
An obvious, horrendous decision which was not resolved without tremendous bloodshed, which followed it, and one could argue directly followed it. What about Korematsu, in which the Supreme Court of the United States permitted the incarceration of Japanese Americans just by virtue of their ancestry? There also, of course, is Brown against Board of Education, where the court had the courage to rule that separate but equal is inherently unequal, something no legislature could ever do. What about Obergefell, where the court had the courage to rule that the right to choose your mate is a substantive due process area of human behavior which does not require a government permission slip? What about Baker against Carr, in which the court said we have to have one person and one vote? Obviously, this goes both ways. The court is an imperfect institution. You know, we have this one-liner here that the Supreme Court is infallible because it's final. It's not final because it's infallible. But the essence of my argument is this: the rule of law cannot exist without an independent judiciary. And the whole purpose of an independent judiciary is to be anti-democratic, anti-majoritarian, to preserve the life, liberty, and property of the minority from the majority's efforts lawfully to encroach upon it. Because ultimately, the tyranny of the majority can be as dreadful to human freedom as the tyranny of a madman.
Well, would you care to respond? It's an awful lot to respond to.
No, I think, as I would expect from one of the few people who is both an experienced judge and an equally experienced television star, that he has encapsulated something complicated in a very simple way, that there is a conflict between these two. If we want the judiciary to be fully independent, then we don't want it to be accountable, because accountable means not being fully independent. And that brings a dilemma. I believe that in the United States, the judiciaries are not fully unaccountable because there are various checks and balances in the Constitution. I mean, a new president can appoint new judges. They can threaten to increase the number of judges. There are different things that the US has provided a mechanism where you have a very independent, but not totally independent court. There is a political interplay which happens slowly. And that, I think, has worked quite well in most cases. It was disastrous in the 1850s. And so we see how it can work badly. The trouble when you come to the European situation is that we have something completely new in that we have unaccountable international courts that are now getting huge power, and nobody has ever thought about this problem of the relationship between the democracy of national governments and these international courts. And so Europe needs to turn to the United States' experience of checks and balances to look at a new situation that we've got in Europe. But underlying all of this, and I completely agree with the judge, that there is a conflict between democracy and the rule of law. And often unresolved conflicts are what we need in human life. If there was a simple answer, then we maybe would have a worse society. But I completely agree with him. There is a conflict.
Well, on that note of harmony, I hesitate to open the floor for questions, but we have just a couple of minutes for a couple of questions or observations. If anybody would want to make them, feel free. Yes.
I wonder if you would tell us what your solution to the problem of the UK and these European, if you would tell us what the solution to the problem of the UK and the international courts is. You said that you had a plan.
Well, I think that what I felt very pleased that the government had followed what I had recommended. But then they'd gone beyond it. In other words, they say that you should merely regard the decisions of the European Court as advisory. No court can be merely advisory. I mean, it's ridiculous. You can't do that. You have to find a device whereby there must be some very special reasons to override a court. In other words, that, and by overriding, I don't mean overriding in a particular case, but in the implications for law. In other words, that it could be by asking for a supermajority, it could be by having two successive parliaments. There must be some barrier to it must that you could lay down that it must be after certain kinds of debate. In other words, it can't be casual. But what I'm actually somewhat at odds with the Conservative Party manifesto, which used these terms merely advisory, is that I think that was too casual. I think in practice, parliaments will not override court decisions on human rights very often. We've found that in Canada, where there's the notwithstanding clause in the Charter of Rights, which allows the Canadian Parliament to override in certain circumstances. I don't know if it's ever done it, but it's hardly ever done it. But I think you must set up a high bar, and the details of that, I'm not a lawyer in that. I would then turn to my legal friends, but it must be, that must be the aim.
I think we have time for one more question. Yes, in the back?
German position that slave labor was not a crime in Germany. But given the standard idea of a law being the law of a land, of a country, and the idea that crimes against humanity seem to have been propounded after World War II, and there was no crime against humanity prior to Nuremberg, isn't the German position that slave labor was not a violation of law, may have been immoral and so forth, a legitimate position?
Well, that was what I was trying to say, that it would appear that there is good ground if you're against retrospective legislation. Then, if it was legal at the time, then what is the objection to it? But we are left, if we fully accept that, we're left with a morally unacceptable position. And so I think I raised this with a friend of mine who is a very senior judge in Britain, and we met after many years. And he said, well, of course, it can't be illegal in that sense, but one may have a special form of law that is propounded, a new kind of convention agreed with the German government, that they will agree to its illegality retrospectively as a special case. In other words, you would have to, since the Holocaust was so unusual, you would need to do something special. But when you have the German government arguing in very callous terms that the slave laborers ought to be grateful, I think you're at a morally unacceptable position. So what I would like to have happened would be that I would like the slave labor negotiations not to have been about money, but to have been about moral principle. And I think that since that negotiation was a very dirty little negotiation about bits and pieces of money, we still have the moral and constitutional questions of how we deal with this to be discussed. And I would love to take part with some legal theorists, both from Germany and elsewhere, in such discussions. And indeed, if there was any appetite within this law school in this great city, which of course has a huge variety of ethnic minorities, I think it would be a very suitable place to start such a discussion.
Well, those are great ideas to conclude on. I want to thank our speakers.
I think we have, I saw Professor Arato's hand up. Do you have a quick question? We can take one more.
Sure, I hope it's quick. I just had a question about the checks and balances that you raised, the supposed checks and balances problem. So there are absolutely not the same checks and balances on the international stage with a court like the European Court of Human Rights or the ECJ. But that doesn't mean there are none. For example, there's no life tenure, and at least one of the judges is chosen by the country that its human rights record is at issue, right? So there are different sets of checks and balances, and I'm a little bit worried that using the idea of no checks and balances as a means to undermine the value of their opinions would really denature what these courts are all about.
I can't answer the question in the brief time, but maybe we can have a word afterwards.
Thank you. What a remarkable panel. And Dr. Pinto-Dushinsky, it is a real compliment to us that you put so much time and preparation in composing your remarks, and I hope that we can have it available, after the fact.
Yes, you can.
Including the missing pages.
Yes.
So we'll now reconvene on the 7th floor.
Okay, I get it.
Correspondence.
No, I get it.